I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 1.4, which is about communication with the client by the lawyer. Now, for my students, a quick point I want to say at the beginning is when you're in practice, this is one of the two rules, along with the duty of diligence, that generates the most complaints about lawyers to the bar and the most grievance or disciplinary actions by the bar against lawyers. Now, the other rules are very important. So conflicts of interest generates a lot of the malpractice lawsuits, legal malpractice lawsuits, and disqualification of lawyers from cases that they were hoping to work on. But this particular rule, even though it's not the most heavily tested rule, is the rule that you are, all things being equal, most likely to face a disciplinary action for in practice. So let's take a look at the provisions of the rule. I think this rule is pretty straightforward about what you have to communicate to the client. So first of all, you have to promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. And the operative word here is promptly. So some lawyers are really bad about procrastinating things, and they think that they won't be subject to discipline because they eventually got around to talking to the client. But actually, if you are required to get the client's consent on some issue, like accepting a settlement offer or agreeing to continue the representation in spite of a conflict of interest, you have to do that right away. Secondly, you have to reasonably consult with the client about the means by which the client's objectives are to be accomplished. I put reasonably in bold. It doesn't mean you have to tell the client every single thing or explain everything you learned in law school, everything about the federal rules of civil procedure, but you need to consult with the client to a reasonable extent about what's involved in achieving their goals. Keep the client reasonably informed about the status of the matter. So if a case has been dismissed or some of the claims thrown out on summary judgment, or you've won a couple points on summary judgment already, or your star witness is not going to be allowed to testify, or your expert wasn't qualified, that's a pretty important thing that you should tell the client about and give them a sense of when to expect action on their litigation matter or how long negotiations will take in a transactional matter. Promptly comply with reasonable requests for information. And fifth, always consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance that's not permitted by the rules of professional conduct or other law. So a lot of times, if your client isn't a lawyer, they don't know that, let's say you're not allowed to have ex parte communications with a judge, and they may ask you to do that. Please call the judge at home over the weekend, talk to them about my case, and you have to explain, I'm not allowed to do that. They may ask you to do something that you can't do that would involve practicing law in a state where you're not admitted to practice, and so forth. So if your client has expectations, you need to spell out to the client, look, I have to work within parameters and limitations of the ethics rules and certain laws that apply. Okay, B, a lawyer shall explain a matter to the extent reasonably necessary to permit a client to make informed decisions regarding the representation. Now, some lawyers are really good about this, and some lawyers are not great communicators, and they don't think the client needs to be in the loop about things. They know what the client needs, they think. And but the client has certain decisions that they should be able to make, and you need to give them at least enough information that they can participate in that. So let's talk about some of the comments here. Comment one basically says, I think the obvious, reasonable communication between the lawyer and the client is necessary for the client to effectively participate in the representation, right? So the client doesn't have to know every little thing. They don't have to proofread your briefs, for example, or know every case that you're going to cite in a brief, or approve of your closing arguments or things like that. But they need to be able to participate meaningfully in the representation and not be kept out of the loop. Some of the model rules require that certain decisions, specific decisions, are always made by the client. And what are we talking about here? Accepting settlement offers or plea bargains. The client has to agree to that. The model rules also require that the client has to agree to the fee arrangement. to division of fees between lawyers if there's multiple firms working on the case, and to conflicts of interest. And so that's just a few of them, and pay attention to that. If the client's consent is required, then you have to consult with the client and talk to them about it promptly. Don't put it off for weeks and months and years, but talk to the client promptly and get consent prior to taking action. And then there's a big unless, or a big exception, unless prior discussions have resolved what the client wants the lawyer to do. So, for example, a lawyer who receives an offer of settlement from opposing counsel in civil litigation or a proffered plea bargain in a criminal case must promptly inform the client of its substance unless the client has previously indicated that that proposal would be unacceptable. So you may have a client that says, I'm not accepting any settlement, I'm going to trial, or I'm not making any plea deals, accepting any plea deals, I'm going to trial, in which case you won't be subject to discipline if you rely on what the client told you to do. In a civil matter, your client may have said, if you get any offer over, if it's a plaintiff, $100,000 accepted, or if it's a defendant, any offer under a certain amount, like $100,000, that they would accept it, or that they want you to reject certain things that are outside of their acceptable range. Now, in practice, I think it's always safer to double check with the client and make sure they haven't changed their mind or that there wasn't a misunderstanding. But for purposes of test questions, a lawyer will not be subject to discipline if a client previously said reject all settlement offers or accept any, let's say, plea bargain that doesn't involve jail time, and the lawyer relies on that and does not have to check back with the client in terms of whether they would be subject to discipline. Next, comment 3, it says, additionally, A3 under 1.4 requires that the lawyer keep the client reasonably informed about the status of the matter, such as significant developments affecting the timing or substance of the representation. So if the court has postponed trial, let's say, for 6 months due to a witness being unavailable or a motion from the other side, that's the type of thing that you have to tell your client about. Well, the other side asked to postpone the matter, and the judge granted their request. Now, in some situations, you can't check with the client. So if you're in the middle of trial and you need to object to a line of questioning from the opposing counsel, you're just going to object. You don't have to ask for a recess to talk to the client about whether to object to something the other lawyer is saying. Or if the judge says, hey, is it okay with counsel if we end for the day and resume trial next week? Let's say a witness is unavailable or didn't show up for trial that day. You can just agree, right? If you don't have a chance right then to have a big conversation with your client. Now, normally, if you agree to something or object to something or do something that the client would want to know about, then you should inform the client as soon as you can afterwards of actions that you've taken on the client's behalf. Now, when a client makes a reasonable request for information, Rule 1.4A4 requires a prompt reply, and I put reasonable in bold, because you could have a client who makes unreasonable requests for information, right? Who calls your office 20 times a day saying, what's happened on my case? And you already told the client, nothing's going to happen on your case for 6 months. Or nothing will happen on this matter for a long time. And I'll give an example. I've done a few nonprofit incorporations over the years and have applied for tax exemption, federal tax exemption with the IRS. Well, that takes months and months and months to hear anything back from the IRS after you send in the forms to apply for tax exemption. And you tell the client that. And some clients get it and they'll leave you alone. Other clients call you 10 times a day saying, is there any news yet? And your answer is, no, there hasn't been any news since the last time you called. I told you that. And so that would be an unreasonable request for information. On the other hand, some clients check in with you every other week or once a month or something like that. And in that case, that's a reasonable request for an update. And when a prompt response is not feasible, at least your staff should acknowledge, whether it's an email or a phone call, receipt of the client's request, and say the lawyer will try to get back to you tomorrow or by the end of the day or by the end of the week. And a lawyer should promptly respond to or acknowledge client communications, whether it's by email or phone or text message. Just let the client know that you heard from them at the least, and when you will try to get back from them. Again, clients get very frustrated. Lawyers underestimate, because they're busy, how impatient clients get when when a lawyer doesn't reply, and it's a very, very frequent um, a, cause of complaints to the state bar disciplinary authorities. My lawyer never calls me back. The lawyer doesn't return my calls. The lawyer doesn't respond to my emails. Now, a client needs to have sufficient information to participate intelligently in decisions concerning the objectives of the representation. Here's a big example. Is your client seeking injunctive relief? Do they want something done, or do they primarily want money damages? And a classic case is the employment wrongful termination scenario. So is your client really hoping to get reinstated to their position and get their old job back, or do they understand that they're unwelcome? Do they feel unwelcome at that place of employment, and they really just want to be compensated and made whole so that they can move on and be able to survive while they look for another job? That's a great category of differing objectives for the representation. Some clients may just want to minimize their jail time if it's a criminal case, and others are will even take a risky move to try to avoid any jail time. Another example would be child custody, right? How important is it to your client to have full custody or joint custody, shared custody of their children in a family dissolution case? And then the means, your client should have some say, information about the means by which this is to be pursued. So if your client is saying, I want my ex to pay child support, then you should give them some basic information about how you go about doing that. If they say, I would like to sue my employer, you talk to them about a little bit about what is involved with that, to the extent that the client is willing and able to have such a conversation. So let's say outside of the litigation scenario, you're negotiating in a transactional matter. You should try to review all the important provisions with the client before proceeding to an agreement. In other words, if you're working on a negotiation and for a transaction, and there's a contract that the parties, tentative contract, go through each provision of the contract and explain to the client what that means in terms of their rights or their responsibilities. In litigation, you should explain the general strategy, right? So are we looking for a win? Are we looking for the least bad scenario? Or what are we trying to do here? If your client, it's good for you to be clear in your mind. Is your client kind of acting out of spite? Are they hoping to punish the other side? Or are they really being pragmatic and wanting to be made whole? Be honest with your client about the prospects of success. Is their case a sure thing? Is it kind of 50-50, or is it a long shot? It's okay to bring a long shot case on behalf of a client. A lot of criminal defendants are probably going to be convicted, right? If they're going to trial, there was probable cause for their arrest. Maybe they've already been indicted and so forth. So you can say, look, the chances aren't good, but it's worth trying. The client should have realistic information about the prospects of success, and consult with the client on tactics that are likely to result in significant expense, or to injure or coerce others, right? Is this going to embarrass the client? Is there a lot of embarrassing information going to come out about their family, their children, or their spouse? Also, some certain types of means of achieving things, like hiring lots of experts or jury consultants, are very expensive. And if your client's paying for that, then you should make sure that the client is on board with that. Now, you won't be expected to describe trial or negotiation strategy in detail, right? Again, you don't have to, if you had a long full semester course in federal civil procedure as a first-year law student, you don't have to teach all of the rules of civil procedure to your client to explain to them how trials work. The guiding principle is to fulfill reasonable client expectations for information, and to be acting in the client's best interest and working for the client's overall objectives in the representation. You can't withhold information to serve the lawyer's own interests or convenience, or the interests or convenience of another person. In other words, don't put off telling the client something to give another person an opportunity to, let's say, sell their stock or settle their case or file a counterclaim. And when it says the lawyer's own interest, this includes having unpleasant conversations with your client. So some clients are difficult to deal with, right? So they're emotionally unstable. They cry on the phone and it makes you feel very awkward, or they have an explosive temper and they get angry and yell and swear and scream and things like that. Well, it's human nature, I think, to kind of procrastinate unpleasant conversations and confrontations that we don't want to have. The problem is that under 1.4, you have a duty to the client to have certain conversations and to have them as soon as possible. So you have to kind of compensate for the natural inclination to say, oh, I don't want to deal with that client today. They're going to lose it when I tell them what just happened in the case. And so I'll call them tomorrow. And then you put it off the next day, and pretty soon days have turned into weeks, and the client has been kept out of the loop about something that they really had a right to know about. And then there's the exception that's kind of a good rule of thumb for all the rules, I think. You won't be subject to discipline for complying with a court order. And you could have situations where a judge tells you you're not allowed to tell the client something. And the classic kind of Hollywood lawyer movie example is you're representing a criminal defendant who's part of the mafia or a drug cartel, and the judge orders you not to reveal to your client the identity of a confidential informant or an undercover agent in the case. Not always. Maybe the client will have a right to know that, but if you're under a court order, then don't reveal it to the client. When you're representing an organization or a group, it's often, obviously, you can't always communicate with all the members. If you're representing a large employer like Amazon or Walmart, you're not going to talk to everyone in the organization. They have thousands and thousands of employees. You're going to address your communications to the appropriate officials or managers in the organization, whether that's the board of directors or their general counsel, whoever has hired you to represent the organization. If it's a small organization, a 3-member partnership, you can meet with all of them. But if it's a big company that has thousands of employees, you're going to be dealing probably with one person or a group of managers in the organization. In some rare situations, a lawyer may delay transmission of information when the client would react imprudently to an immediate communication. We're usually talking about the suicide or violence, right? Not just that the client's going to yell at you or scream or make a scene. And so the only example the ABA gives is a lawyer might withhold a psychiatric diagnosis of a client when the examining psychiatrist indicates that disclosure would harm the client. So they tell you, look, your client's very unstable right now, and I'm recommending that they are not competent for trial or not competent to have custody of their children, something like that. Don't tell them that right now. Give them some time to cool off and stabilize because I think there's a suicide risk. In that case, you won't be subject to discipline if you go ahead and take the psychiatrist's advice. And that concludes our lecture about ABA Model Rule 1.4.